Hello, I'm talking about criminal inadmissibility, and this can impact your immigration application for Canada, whether it is for permanent residence, uh, either through economic or family reunification programs, or for temporary residents. Temporary residents can be visiting Canada, working in Canada, studying in Canada. Hello, everyone. I'm Kamaljeet here, a regulated Canadian immigration consultant, and I do help people with their immigration applications for Canada. It could be sponsorship and other work permit applications, any permanent residence applications or temporary residence. Please reach out if you need any help. And today I'm talking about inadmissibility to Canada. And before we move forward, definitely hit the like button and subscribe to my videos if you enjoy this and you find it useful too. So talking about criminal inadmissibility, foreign nationals with a criminal record, including for non-violent offenses such as driving under influence of alcohol, may be considered criminally inadmissible to Canada. And as I've mentioned before, that Canada does not allow inadmissible people with criminal records to enter this country. And this is true even if they are partners, if they are being sponsored by a Canadian citizen or a permanent resident of Canada. So there may be a process by which they could overcome certain forms of inadmissibility, but we will discuss about this further. And what is the process or the pathway they can overcome this? It is rehabilitation. And rehabilitation is an application process that allows a person who has committed or been convicted of a crime outside Canada to enter or stay in Canada. Rehabilitation in this context under the Immigration and Refugees Protection Act means that the person is no longer considered inadmissible to Canada for a particular criminal offense. A person can apply for rehabilitation if at least 5 years have passed since the act was committed and all criminal sentences have been completed. So in order to be approved for this, the applicant must show that they lead a stable life and are not likely to commit any more crimes as of the time they are planning to apply. And moving forward, they should be able to sustain their life, living a sober life, living a clean life. So in rehabilitation actually removes the grounds of criminal inadmissibility. And one is able to apply for rehabilitation. I will repeat it here because earlier it was more like a brief, just a few lines on this information. But you can apply for rehabilitation if you have committed an act outside of Canada and 5 years have elapsed since the act, or been convicted outside of Canada and 5 years have passed since the end of the sentence was imposed. So a rehabilitated person is someone who satisfies an immigration officer that they are not likely to be involved in any new criminal activity, as we mentioned above, that they are now leading a stable life and are not likely to commit more crimes. This is very important. And if you have committed or been convicted of a crime outside Canada, you can also be, if a certain number of years have passed, you could be eligible for individual or deemed rehabilitation to enter Canada. And you have to make an application for criminal rehabilitation. And So you could be found. Now, what are the crimes under which you could be found inadmissible? These could be a number of reasons. This could be like committing a crime like theft, assault, manslaughter. It could also include driving under the influence of drugs or alcohol, and this is very serious. And also money laundering activities. But if a person is found inadmissible due to security reasons or human rights, human or international rights violations, these are almost impossible to overcome. A person who is 12 years of age or older, but less than 18 years, is considered a young offender in Canada and may not be inadmissible if this young offender was convicted in Canada under Youth Criminal Justice Act or was treated as a young offender in the country which has special provisions for young offenders, or was convicted in a country which does not have special provisions for these people, but they will be inadmissible if convicted in an adult court in a country that has special provisions for young offenders. And also note, there may be a situation where this offender was convicted in a country which does not have special provisions for young offenders, but the circumstances of conviction were such that this person would have been treated as an adult in Canada. Definitely, I would recommend that please seek professional help in these matters. These are very case-specific situations, and a person who is knowledgeable and knows the details of the laws will be able to assist you better. And be sure, as an adult, individual rehabilitation, in case of you are applying for individual rehabilitation, I mean to say, you will be most likely asked to show that, that at least 5 years have been passed since your sentences ended, as we discussed, shared above. And this will include any period of parole or probation, and you have a stable lifestyle with a stable home, permanent home, decent, some employment, and letters of preference that show that this person is of good character. And if you're outside Canada, you can send your application for rehabilitation to the nearest visa office. And if you are in Canada, send your application to the nearest IRCC office, wherever, whichever province you are located. The application is the same to overcome criminal inadmissibility. The form is the same. And but if 10 years have already passed since you completed all the imposed sentences for the conviction that you were, involved with, this will include any probation, fines, or any other conditions that were imposed. If you have, if you have gone past these 10 years, you may be considered as to be deemed rehabilitated. For this, you will not need to submit an application to be, and there is no cost to it. So if all the requirements for a deemed rehabilitation are met, you would be admissible to Canada. So, and sometimes an application for a temporary resident permit may be made to consider, you can consider this application if the need to enter Canada is very compelling, and it is sufficient to overcome any risk that they may pose. So it's not that you will be granted a temporary resident permit, but definitely there is a very strong compelling reason that you need to come to Canada and 5 years have not really passed, like just an example, if 5 years have not really passed since the offense was committed and you need to travel to Canada, maybe you have some family, you can be any reason. So you can definitely apply for this TRP, the temporary resident permit, and see if they will approve it. And if also if a family member was examined to be found, and was found to be inadmissible, the applicant will be found inadmissible as well. So these are some very important points that I very briefly wanted to share. I'm not sharing this in detail because it is very individualized, that it depends on case-to-case basis what and how can a person overcome criminal inadmissibility. There are so many situations that happen, and but definitely try to apply to overcome criminal inadmissibility. There is a form which you can complete. The form is called application for criminal rehabilitation, and the number of the form is IMM 144. And you can please take a look at it on the IRCC website. And it can be, there are many situations where a person is able to apply for rehabilitation once again, and if you're not, then definitely seek some professional help to understand your situation better. There may be some other ways that you can apply. If there is one is TRP. Other things, a professional will be able to advise you better on your situation. Reach out if you need some help from me. I am happy to assist. My email is below.